Everybody wants to find the perfect match for their financial needs. Secured savings, stress-free access to affordable loans, instant mobile money transfers to MTN and Orange Cameroon, and even a share in the profits as a member owner. For over 7 years, RENCAM Credit Union has been the perfect match for Cameroonians living in the UK and other nationals with interest in the Cameroonian heritage. Visit rencam.co.uk. Join RENCAM Credit Union today, achieving success together.
Hey, sometimes we don't see eye to eye, but you know I'm on your team, so why you fronting, pretending that she's the right one for you? See, maybe it's safer to pretend that you don't see me, but when we kissed, I knew that you caught feelings. So maybe I'm gonna give you something incredible about things you love. Something to love. Something to love. So why you fronting on me when I got your heart behind my back, yeah? And I called you last night. Never mind that you didn't know. I don't know if that will do. When you come around me, boy, begging me, try to act like it don't matter, but you know you got me all real. This ain't real. All these crazy thoughts about you. All these crazy thoughts about you. See, maybe it's safer to pretend that you don't see me. But when we kissed, I knew that you caught feelings. So maybe I'm gonna give you something incredible. Something to love. Something to love. Something to
Hello, good evening. Thank you guys so much for watching. Hi, Kende. Hi, Auntie Louisa, and all the others who are watching. Welcome. Welcome to another episode of The Woman Experience with me, Goretti. Thank you so much for spending your Friday evening with us. We appreciate that. So if you're new to the show, you're very welcome again. The show is called The Woman Experience, and I'm the host. And we normally have our main guest of the evening, and you who's watching, you are considered our guest. Our platform really is just a platform where we come together to learn through our shared experiences. We're very strong believers. The Woman Experience Tribe is what we call ourselves. We're very strong believers in your experience being your most powerful story. And so we come here every Fridays. We are now a weekly show. We are on episode 54. So we have 54 great episodes for you, 53 great episodes for you to go and spend a couple of hours watching. We have talked to everything. We've touched, well, not everything. We've touched on almost everything. So from love to grief, by the way of domestic violence and autism. We've talked on it all. So spend a couple of hours if you can on our page. On Facebook, it's the GORETTI Experience page, and on YouTube, it's the GORETTI Experience page. Subscribe, like our pages so you can stay abreast. So once again, thank you so much. We're very, very interactive on this platform. So whatever comments you have, any suggestions you have, any resources you have with regards to what we are talking about at the moment, just leave it all in the comments. Leave it all in the comments. And what I try and do is I bring it to the stream and I read it and the guest answers. And even if your question is not answered, if someone's asking a question in the comments that you think that you have the answer to, or you have the resource to, or you have somewhere you can point that person to, please just go right ahead and answer in the comments. Because again, like I said, what we do is we learn through our shared experiences. And every now and then we are so lucky to have an expert on a particular topic like we are today. And so when we have that, we really encourage you to share it far and wide to whomever you think may benefit from from this conversation we are having tonight. Tonight we are talking about Brexit. This is more relevant to people in the UK and people who are thinking of relocating to the UK. So if you have anybody who's, currently in the UK and who is not yet, doesn't yet have that passport, please share this information, share this show with them. So we're talking about Brexit and waiving immigration fees. We're talking about non-molestation orders, and we're talking about your cohabitation rights. Before we go into the show, I hope you can see me clearly. Can you see the lipstick I have on? I am so excited to be one of the brand ambassadors for this brilliant brand. This is Skylar Glam. It's a Cameroonian-owned brand. She makes lipsticks, and I'm going to be rocking her lipsticks for the duration of this Woman Experience show. So hey, thank you very much for coming on board, Skylar Glam. We are very, 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 very honored to have you. And if you haven't already, I will leave her link to her website on the show. So go check. That's the young lady, very powerful girl. I'm so, so proud of her. Welcome, Auntie Yeti. Welcome. Thank you for coming. So straight on to now, like I said, we're talking Brexit. We're talking Brexit, and our guest of tonight is my sister. But in this capacity tonight, she's a professional. She is Jackie. Okay. She has qualified as a solicitor in the UK and has been practicing for over 19 years as a solicitor. She currently works at Solomon Shepherds Solicitors in Tottenham, London. So without further ado, I'm just going to bring the very, 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 very beautiful, intelligent, smart sister of mine, Auntie Jax, to the stream. Hi.
Hello. Thank you for having me.
Thank you very, very much, Auntie Jackie. What? Okay, no. Should I don't know how not to call you Auntie Jackie.
I know. I might call you Anu as well, but
that's fine. And don't worry, even though I'm calling her Auntie Jackie, she's not that old, It's just It's just like a pet name, right?
Pet name, yes. We stress on that.
I stress on that. But thank you so much for coming. As you all know, especially for those of us in the UK, so we have Brexited, and our the transition period comes to an end on the 31st of December.
That's right.
And so 2020. So 1st of January 2021, there are new rules for businesses and citizens. And Auntie Jax is here to talk to us about how this will affect us, especially in terms of those immigration rights. Right, Auntie Jax?
That's correct. That's correct. So, like you rightly said, we're Brexiting. We have Brexited, and we're within the transition period. And so today, really what I want to speak about, and I'm sure a lot of people have a fair idea of what they need to do, but just to stress and to give information to those who don't, what you need to do to secure your immigration status here in the UK, secure your position in the United Kingdom. And so there are two things you can do. You can either apply for settled status, or you can apply for pre-settled status. Now, this applies to European citizens and their dependents. So a European citizen is anybody who is a national of one of the European Union countries. So if you want to stay or reside in the United Kingdom, then you can apply to stay either under the pre-settled rules or the settled rules. Now, for pre-settled, you would need to show that you are exercising your treaty rights before the 31st of December 2020. So you're either working or studying or receiving a pension in the United Kingdom. All those are ways that you exercise your treaty rights. And you've done that for less than 5 years. So if you can show that you've done that for less than 5 years, and it doesn't matter how short it is, even if it's 1 month, you can then apply for pre-settled status. And you get 5 years to stay in the United Kingdom, after which you can apply for settled status or indefinite leave. So that's for those who haven't lived continuously in the United Kingdom, exercising their treaty rights for 5 years. So they can apply for the pre-settled status for themselves and their non-European dependents. So if you've got a wife, children, mother who is not European, not a European national, you can apply for them to stay in the UK with you under the pre-settled status rules. So
come 1st of January, you can't.
No, you can. There's a big difference. So you can make this application up until the 31st of June 2021.
Okay.
So as long as you're in the United Kingdom, you've got up until the 31st of June 2021 to make the application. And the same applies to those who have been here continuously for 5 years. They can apply for settled status. It's almost like indefinite leave to remain.
Sorry, question. So what does that mean? If you're here as a student, can you apply for settled status, or you must be? Or
you can. So if you've been a student for 5 years continuously, or mixed, 2 years as a student and 2 years working, whatever combination, as long as it's been continuous for 5 years, you're eligible to apply for it. Of course, there are other criteria that come into play, but that is the standard rule: is the 5 years continuous treaty rights exercising in the United Kingdom. So once you can show that for 5 continuous years, you can apply for settled status. And then if it's less than 5 years, it's pre-settled status. Both statuses enable you to stay and work in the United Kingdom after the 31st of December 2020.
Okay, and if you don't qualify for pre-settled status and that, so let's say you haven't been in the UK for up to 5 years, and you don't qualify for either.
Well, you need to. Then you'll struggle. I mean, as long as you're in the United Kingdom, and these are the two deadlines. You've got the 31st of December. So just to make it quite clear to the audience, you've got the 31st of December, which is the deadline to relocate to the UK. So if there's anybody out there in Europe or in Cameroon or in Nigeria, wherever you are, and you want to relocate to settle in the United Kingdom, and you want to qualify under the European laws, you have to do that before the 31st of December 2020. After that date, you can't relocate, you can't qualify. Now, for example, if you do come in on the 29th of December 2020 and you have a job and you're exercising your treaty rights, you're fine. You can then make your application up until the 31st of June 2021. Does that make sense?
Yeah.
Okay. So locating is the 31st of December. Making the applications, you have up until the 31st of June. 31st of July.
31st of July.
Of July. Sorry, my mistake. 31st of July 2021. So those are the two deadlines that people need to be aware of.
Okay. So what type of documents do you need to put together? Maria is asking.
Documents you need would be, the most important thing would be exercising your treaty rights. So if you're working, pay slips. If you are a student, you'll need to have a letter from the university or college or whatever establishment you're attending. You would also need to show that as a student, the rules are slightly different. So you would need to show that you have private health insurance if you're a student. So it's slightly different. But really, all you need is your pay slips, tenancy agreement to show you're living here, bank details, proof of address. That's really what you need. If you are self-employed, that might be a bit tricky if you come in too late, because you'll need to show that you are, you need to have evidence from HMRC that you're self-employed. If you're an employee, that's quite easy because you can get a letter from your employer, or you can have just one pay slip and that will suffice because of the deadline. So, important thing would be evidence of exercising your treaty rights, proof of address, your ID. Of course, you need to have some form of ID to do that. And for your dependents, you need to show the relationship between you and the dependent. So if it's a wife or a husband, a marriage certificate, children, birth certificates, and so forth. Your mother would be your birth certificate to show that she's your mother, and evidence to show that you've been supporting her, or whatever it is you can show to prove the relationship between you and mum or parent. So, in a nutshell, those are the documents that you will need. Of course, every case is different, and some might be a bit more tricky than others. And so the advice is, get these documents if you're thinking of doing it, but seek advice. It's so much better, and you save yourself a lot of hassle down the line if you just go for a consultation, either Citizen Advice Bureau if you're struggling with fees. They, of course, are fully booked most of the time, or some firms have free consultations, or it's just worth paying the consultation fee to get it right. Because most of these applications are fairly straightforward. You can do them yourself, but just get the guidance that is required in order to get it right. Because once you're refused, any application subsequent and after the deadline would be refused, and then you now fall within the general British immigration rules, which are a lot more stricter and a lot more difficult to get your leave, especially if you haven't got any status, so you haven't got any leave at all, i.e. you're illegal in the UK, you won't be able to regularize your stay easily. So important to seek and get advice before doing anything. Like I said, we only have another, we're now in November, so we've got technically 9 months, let's see, July, August, 9 months to make an application. So you want to seek their advice earlier so you can get the documents ready to enable you make the application in order that it's successful.
That's a short amount of time left.
It is, but we've known about this for quite a while, so it's just some people are not aware. That's the difficulty, hence the reason for the show.
Actually, quite a lot of people are not aware, because a lot of people, when they saw that way, sent me private questions asking, "Oh wow, they weren't even aware of this." So, but what about those home office fees? Tend to be very high. And Jackie, is there any way to can you apply to have your home office fees waived?
Yes, you can. Now, fortunately for European citizens and their dependents, the applications are free. So you don't have to pay anything if you are applying as a European citizen. So which is great. So like I said, get advice. The fees would be practically nil unless you're being represented by a solicitor, and you make your application, and that's fine. Now, for those of us who are not Europeans and we are struggling, as you know, the fees are absolutely crazy. They went up on the 26th of October. This is the IHS fees. The IHS fees is the immigration health surcharge. And this is almost like an insurance you pay for the National Health Service. Now, it started off initially at about $250 per year that you'd pay. And so, it used to be £500 you'd pay a few years ago. Then it went up to £1,000. And now it's £1,500 per applicant. And that is just the immigration health surcharge. Then you also have the Home Office fees, which range between £1,000 and £2,900.
Wow.
So the average applicant who has got 2 children, mother, father, and 2 children, you're looking at least £10,000, £12,000 to submit an application in the United Kingdom to the Home Office. Those fees are absolutely mind-boggling.
Yeah.
And so for a lot of people, they don't make the application that they need to do. They become overstayers because they haven't got those fees to make the application. And for those who have tricky applications that need to be made, that they require legal assistance, you have on top of that the legal fees that you have to pay.
Yeah.
So there is it's not a concession, because a few people have asked me whether it's a concession. It's not. It's a fee. It's a waiver of the Home Office and the IHS fees that will enable you make the application without having to pay the Home Office fees and the IHS fees. So not all applications are eligible for the waiver. So you have to be at least lawful in the United Kingdom to start off with. If you're going through the 5-year parent route or the 10-year parent route, and those who know what I'm talking about will understand. So it's an application you make on the basis of children, or if you're married, it'll be the 5-year route. If you've got children in the United Kingdom, it'll be the 10-year route, and there are various degrees of the 10-year route as well. There's also the making an application under Article 8. Now, these are usually applications that you make, not necessarily because you're lawful in the UK, but because any refusal of an application will breach your human rights. So I'm not going to go into the details of that, and I'll suggest that anybody who thinks they fall within that category should seek advice. But in essence, you get those fees waived, and you'd have to show that you are destitute, that you are not able to afford the fees. That's one of the criteria. You're not able to afford the fees, that you are destitute or you are at risk of destitution, and that your income is not sufficient enough to meet your needs and those of any children. So, it's, in essence, you have to show that you haven't got the money, despite you being able to work, or because you're not able to work, you haven't got the money to pay those fees. So it's a simple application that you make online. Again, you'd have to show that you're destitute or you're unable to afford. They will scrutinize you. So you'd have to provide pay slips if you're working. They'll look at your income and what your disposable income is. Your expenses will be taken into account. Your bills, your rent, all of that will be taken into account on the backdrop of your income. And then the Home Office will have a look to see what your disposable income is and whether it's reasonable to expect you to have saved that towards an application. Now, I can tell you that, at our firm, we have in the last 2-3 months made at least, I'd say, 25 applications for fee waivers, and none have been refused. Of course, we don't make the application, we assess each applicant. And if we don't think you're entitled to it, we will not even consider it. But it goes to show that there is hope for those who are struggling with the fees. They will also consider whether you're able to borrow money from a friend or family. So those are things that you need to bear in mind. If you've told the Home Office in the past, I've survived because friends and family have borrowed me money, then the question is, why can't they borrow you? Of course, you can always negate any of that. But all these things will be taken into account in deciding whether or not you're entitled to a fee waiver. But it's so important for a lot of people to consider this, because it makes a difference between you making the application in time and not making the application in time. So very important to bear that in mind.
Marvels says that you forgot to mention that NHS workers, including carers and support workers, can claim back their immigration surcharge since March this year. This
That's
came in
right.
force from October 1st.
That's right. Thank you very much for that, Marble. It is correct. And this is to do with key workers within the COVID pandemic that we faced recently. So you are able to claim back your IHS fees from the 1st of October, yes. So it's something that if you are a key worker working in the NHS and you've made that application, you can claim that fee back. And it's a lot of money, you know, that so both the IHS fees you can claim back and the Home Office fees.
Thank you for that. Thank you very much for that, Auntie Jackie. So in summary, can you just summarize it into like bullet points?
In summary, with respect to immigration health surcharge, if you are unable to pay the fees, if you're on a low income, if you have children and unable to work for whatever reason, and you need to renew your application, or you need to submit a fresh application, then consider applying for a fee waiver, Home Office fees and IHS fees. You would need to show that you are destitute or you are unable to pay the fees, or you're on a very low income. But it's not hard. If you are genuinely in that position, you should be able to provide that evidence, and decisions come back within 10 days. So, you know, usually within 10 days we get a decision, and then you've got 10 working days from that decision date to submit an application to the Home Office. So please, please, please consider this for those who are struggling. And even if you think, you know, you might be okay, still have a look at it. You just don't know that whether or not you will qualify. And in the absence of, you know, being able to check this online yourself, you know, call a firm of solicitors. A lot of solicitors are more than happy to just give you that advice over the phone. And then if you need the consultation, you can come in to see them.
And I'll just take it a few steps back in again summary for before we move on to the next bit. For people who are currently in the UK and hold an EU passport, what are the deadlines and what do they need to do? Okay.
So the deadlines for European citizens and their dependents, if you want to relocate and live in the United Kingdom and you're not here already, or you're not exercising your treaty rights already, then you've got to the 31st of December to do so. So being a European national and living in the UK and doing nothing doesn't allow you to stay in the UK under the European rules. So you need to be exercising your treaty rights, working, studying, any one of those. So you need to do that by the 31st of December. And all European citizens who are present in the UK as of that date have until the 31st of July to make an application for either pre-settled status or settled status.
Thank you for that. And welcome, Shinal. Welcome, Cleo. Hi, Cleo. And welcome, Piers. Welcome, Kizzy, Yetunde. Welcome to the Woman Experience Show. And we're just going to go on a short break, and then we'll come back, and then we'll move on to cohabitation rights. So thank you for that.
Everybody wants to find the perfect match for their financial needs. Secured savings, stress-free access to affordable loans, instant mobile money transfers to MTN and Orange Cameroon, and even a share in the profits as a member owner. For over 7 years, RENCAM Credit Union has been the perfect match for Cameroonians living in the UK and other nationals with interest in the Cameroonian heritage. Visit rencam.co.uk. Join RENCAM Credit Union today, achieving success together.
Welcome back, Auntie Jackie. Hi.
Thank you. Hi.
Welcome back to the Woman Experience. And if you're just joining us, because I see a few people are joining us now, this is the Woman Experience, and it's a weekly show every Friday, 8 p.m. GMT. Well, I'll just say UK time, every Fridays. And what we do here is we learn through our shared experiences, and every now and then we are lucky enough to have a wonderful expert on the show on particular topics to talk about, to give us a lot more information on what we're talking. And if you're just joining us, we'll be talking to solicitor Jackie Oke, who has over 19 years as a solicitor in the UK, and then she currently works at Solomon Shepherds Solicitors in Tottenham here in London. And we've been talking, this first part of the show, we've been talking about the Brexit and the impact or the effect of Brexit on immigration, on our immigration rights and status. So We're moving on to the next part of our show, Auntie Jackie, and we're going to be talking about cohabitation rights. You know, just recently on the show, on one of these shows, did I have to do some research that I found out that I'd always heard that there was something called, what's that thing?
Common law marriage.
Marriage, and that the common law marriages, you had some rights, but I realized that it didn't exist anymore.
No, it's never existed. So there's never been anything.
So it's
never existed.
Oh dear.
It's a myth. People just seem to think that because they're living in a relationship akin to marriage, that they've got matrimonial rights. You don't. And it's so sad that the rights don't follow in such relationships, because, you know, over 20% of the population in the United Kingdom actually cohabit. And so it's, you know, it's important for you to understand, especially for our people, and most of our audience who
yeah, and for those from Cameroon who are watching, cohabitation, common law marriage, as we all assume existed, is camuste. So we always assume that if you've done camuste for a few years, you would have some legal protection in place, and Jackie's just telling us that's not the case.
No, it isn't. I mean, you don't really have a lot of rights. So you will need to. The whole point of this is for people to understand what they can do to establish those rights, and for those who are in a relationship in which they would like to go into going forward, would like to stay in a common law marriage, so to speak, or relationship, what they can do to protect their rights down the line. So the starting point is, you know, what sort of relationship is considered a cohabitation relationship. And really all it is just where two people are living together who are not married, and who to each other, or who are not in a civil partner relationship, but they're living together as if they were married, or as if they were in a civil relationship. So that's all it is. It could be any two parties. It could be, you know, a heterosexual relationship, a homosexual relationship. As long as you're in that relationship and you're living in the same household, very important, you should be living in the same household. And there is, there may or may not be a sexual relationship, but usually there is. There are children, and there is to a certain extent, a combination of financial, so the finances are joint. Not always the case, but the most important thing is, you know, two people living together in a relationship which resembles one of a marriage. So if you're in such a relationship and you think, you know, that I've got rights in this relationship, you need to really consider that carefully, because two things. One, if your partner passes away, you then find out that intestacy rules do not apply to cohabitees. So you have no rights over their bank accounts, their estate, nothing at all, unless they've left it in a will. And you know the difficulties we face in our communities, whereby you're living with a partner, the husband or the wife passes away, and the family get involved. Now, they would have more rights than you do over any assets or over anything that your partner has, because you're technically not related to them. Now, it might vary slightly if you've got children, but if you don't, then, you know, it's a bit of a struggle. So you need to ensure, one, that you both have a will. So important to consider getting a will in which you could declare what you want should you, you know, pass away. You know, who should get what, and how, and so forth. Another thing you could do is enter into a cohabitation agreement. Now, this is just a standard contractual agreement between two parties. You can put anything in that agreement. Who should benefit from, you know, the property, what shares we've agreed to pass to each other. And the cohabitation agreement is different to the will, because the will takes effect on death, whereas a cohabitation agreement is one that will take effect on separation, for example. So you understand and you both agree what you want to go in there. Who should have the children? Maintenance for the children could be considered in the cohabitation agreement. You know, so you can put anything in there that you wish to be bound by down the line.
Must it be done by a solicitor, or you can just write it on a piece of paper and both of you sign it?
you can do that. It's always best to seek advice and have it drafted by a solicitor. And I say this because there are a lot of things that you may not consider that would need to be considered and included in the agreement in order to make it concrete. And of course, you want to ensure that both parties understand what they're getting themselves into, because of course, if one party is not quite clear about what is happening and feels they're being bullied or pressured into agreeing to that, then it could be deemed to be invalid, the agreement. So you want to be sure that both parties are going into the agreement knowing what they're doing and are fully aware of what the intention of the agreement is down the line. So that's very important that both parties understand. And so in order to do that, it's always best to get a solicitor involved, because a solicitor can advise you and say, are you aware that this means that and that means this? Are you sure you want to do this? And so forth. And once witnessed by an independent solicitor, it could be witnessed by anybody, but more so a solicitor, it carries a lot more weight, because the understanding is that you were thoroughly advised and you understood the implications of going into the agreement. So those two things, a will and a cohabitation agreement, are ones that you should consider if you're going to a relationship as what we've discussed recently, or if you're in one and you think, it's something we need to think about, because we don't know what can happen down the line. Relationships, as much as we like it to last forever, don't always last forever, and it's wise to prepare for these sort of eventualities. Okay, so that's what you can do to prevent any difficulties down the line. Now, for those who haven't and are in the relationship and they can't withstand, and things have gone absolutely pear-shaped, you want to know that you've got rights. And usually it's to do with the property, because of course, you're living in a property with a husband or a wife, and 10 years down the line, you're being asked to leave because, you haven't got rights. Now, usually when you purchase a property in the United Kingdom, you will purchase it in two ways. One will be as a joint tenant. And what that means is that you purchase the property jointly. So you both own equal shares in the property and you hold it on trust for each other. Now, that sounds a little bit complex. I'm going to try and break it down. What that basically means is that you both hold equal shares, and if one passes, the shares automatically passes to the other party. So that's joint tenants. That's what it is. In those circumstances, the courts really look at the circumstances, and it will start from the point that both of you own it equally in both shares.
So in this case, is this when it's a marriage, or
no? Because you can also hold it jointly as partners. Yes. Okay, so you can hold it jointly as partners. So you can hold it as a joint tenant. So that's the first, and the second will be a tenant in common. Tenant in common means you own separate shares. It could be equally, it could be 30-70, it could be 10-90. It depends on how you choose to own or to hold the shares. And so with tenants in common, that would be evidence of what your rights are in the property. So if you hold it as a tenant in common, if it's not declared or not evident on the transfer deed, then you're deemed to hold it 50-50. Otherwise, you need to apportion it accordingly to what you want. Now, it's so important to understand that with these two, it doesn't mean that irrespective of the way you hold it, you're entitled to those shares, because that could change down the line. So, for example, I purchased a property with my partner as joint tenants, meaning we own it equally and hold it on trust for each other. And my partner decides, the relationship is not working, and he decides to take off for 20 years. And then 20 years down the line, the property that we bought at 30,000 is now worth 500,000. He's not paid the mortgage. He's not done anything, but he's the legal owner of the property. He's half legal owner of the property. Yeah. And technically is entitled to that amount of equity, that, half of the amount of equity. Can he get that? Well, the courts will look at a lot of things. One, the intentions of the parties at the beginning and how it was displaced. Now, if you leave the property for 20 years, or however many years that is, and you haven't contributed at all financially to it, you can't come back and expect to get the benefit of the increase in value in the equity. And so the courts will look at quite a few things in order to establish whether or not you should be entitled to it. And so for those who decide to leave and think they're going to come back and get, I'm not going to, incur the cost, but I'm going to get the benefit, it doesn't work that way. Okay, and so vice versa, it's the same way. The person who's paid and contributed and worked is more likely to get substantial, if not all of the equity compared to the person who left. Now, this is all well and good when both parties are legal owners in one shape or form. A lot of the times, especially in our community, there are people who buy it in their sole names, and then they have the partner living with them. And the question is, what rights do I have? Relationship goes pear-shaped, and they say, well, get out of the house. You don't have to stay here, and they think, well, my name is not on the property, so I have to go.
Yeah.
Not necessarily. You can make an application under, it's called it's a very complex with Trust of Land and Appointment of Trustees Act, but in short, it's TOLATA. You can make an application under TOLATA for a share or to establish that you have a beneficial right in the property. Now, the courts will look at various things in coming to a conclusion or decision as to whether or not you have a right in the property. And one of them would be whether or not what the intentions of the parties were at the beginning. When you bought the property, what was the intention? Was it for us to build a family together? Did we have children? And did you always believe that this was our family home? If you can prove that, and that can be done by various means, text messages, emails, witnesses, then, the intention was that it was meant to be for both parties. And so she or he, whose name is not on the title deeds, will be entitled to a beneficial interest in the property. That will be a portion according to the courts as well, because each case will turn on its facts, but it doesn't mean you're not entitled to anything. Another thing the courts will look at is whether or not you were led to believe that the property was yours. You had an interest in the property. So if the wife says to the husband, you know what, no, go fix our kitchen or change the whole kitchen, change the bathroom, or he's working on the bathroom and he's saying, well, this is our home, so I'm a builder, I'm going to do the works because this is our home, and you've led them to believe that yes, it is our home, and they've acted upon that belief. So it's very important. There's a belief, you've acted upon that belief to your detriment. So i.e. you worked 3 weeks each month or whatever it is in order to improve the value of the property, when you could have been doing something else with your time. That will be taken into account and would be ruled by any court that you acted upon a belief to your detriment, and therefore you have a beneficial interest in the property. So these are things that the courts will look at. Have you contributed towards the purchase of the property? If you contributed towards the purchase of the property, then of course you won't do that. Nobody gives money towards the purchase of a property if they didn't intend to have any interest in it. So a lot of the times, I say to people, keep evidence of, transfers. If you're doing works, I know it sounds, sad to say that because you're in a relationship and the whole idea is that, it will last forever.
Yeah.
But you and I know sometimes it just doesn't work. And I'm not saying go and make a conscious effort to, keep and make a note of everything you do, but just be aware that these are the things you need to prove down the line. And knowledge is power. And so if you know and you understand, more often than not, people will act on that knowledge and try to prevent it. And if they can't, they know what they need to do in order to rectify it. So, these are the things that you need to bear in mind. And for those who have no intentions of their partners having an interest in the property, don't say to them, this is our home. Make it quite clear from the onset, nama own. Buy your money, buy your own. You understand? Make it quite clear. Don't lead them to spend money, invest in the property, and then down the line you say to them, you've got to leave. It just wouldn't wash because you will not get away with it. Another thing the courts will consider in situations like this is the welfare of children. You can't ask a mother who is a primary carer or father who's a primary carer to leave the house because the name is not on there. He says, so all these things, have you acted on a belief to your detriment? What were your intentions? Are there any children? You have to consider the welfare of the children. And in some circumstances, the court will actually allow the non-legal occupant to stay in the property to the exclusion of the legal occupants. Now, a lot of things come into play there because can you afford to pay the mortgage and so forth. But it's applications that could be made. And like I said, it's just worth getting advice from a solicitor with respect to your rights. And once you've done that, then you know whether you've got the right or you haven't. And if you're setting up to, your partner is going to buy a property, and you're contributing towards it, of course, it's all well and good to make the transfer to the solicitor who's going to do the conveyance, but then set up a declaration of trust. It's a document that any solicitor can prepare, and it's registered against the property. So you're not a legal owner. All you are is an equitable owner, or you have an equitable interest in the property. But what that shows is that you have contributed, and the deed will establish clearly and will state exactly what your contribution was. So that is what will be used in order to establish what your interest is in the property down the line, and what the intentions of the parties were down the line. So, you know, if you haven't done a will, or you haven't gone into a cohabitation agreement, and you're going to buy a property, consider a declaration of trust, so that you can outline what the intentions are and what you hope for in the future. Consider also, you know, whether or not you want to keep evidence of money transfers. You want to speak to your partner about, you know, what the intentions are, and note them if you can. I know it sounds really sad to say, but it just helps down the line when you have physical evidence of what the situation is to protect you down the line.
So this is very informative. It's very important, guys. Nowadays, we don't fall in love. We literally walk into love with our eyes wide open, because we all wish for the best, but the reality of life is shit happens. I shouldn't say that, but
it doesn't always work out the way we'd like it to, and with the best will in the world, sometimes it just
life happens.
So be prepared, be forearmed, you know, and see how that goes.
Angel suggest even married people staying in the same house, better add everyone's name to all loans, etc., before you carry the cross when they decide to leave.
Well, yes, I mean, it's not always possible to add everyone to the loan, and sometimes one person's credit record is better than the next person's credit record, and so you can't always have it that way. And if you need the money, you need a loan, which is very different to a mortgage. Not very different, but substantially different, because the length of the term is a lot shorter and the interest rates are a lot lower for a mortgage. But if you can, yes, add everyone to the mortgage, but that's not always possible. And as long as you're aware of what's going on, you know, that's the important thing. You know, be honest with each other as to what your intentions are. It just makes life so much easier for you down the line. And I know when the relationship breaks down, you know, tensions are high, you're angry with each other, you know, then at that point you can't really think straight, and you're being ruled and governed and directed by the anger and of what's going on. So it helps to make these decisions when you're all in love, whether you've walked in it or you've swam in it. Make those decisions then, before you get to that point when you are not really thinking properly. So that would be my advice. Try and prepare, but if you can't, of course, if you can get everyone's name on the title deeds, do that, but just be aware of what your rights are, and for both parties. So for the person who is the victim and for the person who is, you know, the sole owner of the property, wanting to kick the other person out. So important for both parties to understand, you know, what your actions will mean to a third party or any court down the line. So make your actions quite clear, and you could disguise it as much as you want, but the evidence will be the evidence. And like I said, even being a joint tenant, even if you had a tenant in common whereby the legal one owner had 10% and the other one has 90%, if it turns out that the person with 10% is the one who stayed in the property and has done all the work, and now you with the 90% did nothing at all, that could be displaced. So, you know, your intentions and your actions are very important. And so make those clear. And for those who are on the receiving end, clarify. Always ask questions. It's not always possible, I know, but always try and ask questions. And, you know, just to be certain as to what the intentions are. Intentions is so important, because that's what's looked at a lot when you go to court.
Oh, sorry. Okay.
was a lot to take in, but yeah. But thank you, honest. That was really informative. I'm just thinking, I'm thinking in a case of when children are involved, and this is not about property and Auntie Jackie, and I know we're not, but can you child support? How does it work?
Okay, I mean, in essence, whether you are in a relationship or not, if you are the parent of a child and you are not the primary care of the child, you have an obligation to support that child if you're working. Okay. So, the Child Support Agency deals with these sort of matters. And for people who are working, you can easily go onto the Child Support Agency and there's a calculator, and you can put in the information and it will tell you based on how often you see the child, whether the child stays with you or not, how much you need to give by way of maintenance to the mother. Now, I know a lot of people say, I'm not giving the woman any money, but it's just the way it is. She's a primary carer. She knows what the child needs, and you have to give the money to her. If you don't, the Child Support Agency will deduct it from source. So they will make an application to HMRC, and they'll deduct the money, or to your employer, and they'll deduct the money from your pay package before you even get paid. It's not really worth it, to be honest, to go through that embarrassment. So, if you've got children and you who are not living with you, then you should at least consider looking, into this and paying what you need to pay. In the absence of that, if you've got a property, and the same way with, cohabitees, the courts can also look to award money towards the maintenance of the children from the property. And that's a completely separate area, which hopefully sometime we'll discuss down the line, because it's a lot more complex. But yes, it is possible to get that from the property. But the main avenue for parents who are primary carers wanting to get some sort of support from the other parent is to go to the Child Support Agency. Of course, it's a lot easier to agree amongst yourself. Go on the calculator, establish how much it is, and set up a payment to go to the mum. But in the absence of that, then it will be the Child Support Agency who will determine what needs to be paid.
Okay, just a question here. Is it always the mother who is the primary carer of the child? No, it's not. Of course, the way nature has it, mothers give birth and nurture the baby. Not always the case. I have quite a few clients who are male and are the primary carers. So a primary carer is somebody who deals with the day-to-day care for the child. Takes them to school, feeds them, does everything with them. And usually it's sometimes it can be both parents who do that equally. And in such circumstances, and this is obviously outside the remit of what we are discussing, but in some circumstances, the court will award joint residence for the parents. So the child stays 1 week here and 1 week there. Yes, it does happen in the UK as well, even though it's not as common as it is in Europe. But yes, it's becoming a trend that fathers want to have a lot more input in their children's lives. And so you can do that. A lot of things are taken into account. And again, this is outside the remit of this discussion. But, answering the question, no, not only mothers are the primary carers, fathers can be the primary carers. Primary care is not something that is given to you. You have to be actively caring for the child on a day-to-day basis. And the child sees you as such in order for that to be the case. Thank you very much for that, for answering that, Auntie Jackie. So we'll move on to domestic violence. People will find themselves in that. Tell us about their rights if you're being abused. And yes, I mean, domestic violence, we all know what it is. It could be physical, it could be psychological. It doesn't have to be a physical act. It could be psychological abuse. It could be intimidating, harassing behavior, coercive control. Coercive control is when somebody does something repeatedly in order to control you, control your finances, and it makes you feel intimidated, and you're intimidated by this person. So, it could be any of those
of those that I've mentioned above. Now, so you can apply if you feel that your life is at risk, or your children's lives are at risk for whatever reason. You can make an application for a non-molestation order. Now, all this is it's kind of like an injunction, which prevents whoever the perpetrator is from harassing you or being physically violent towards you, psychologically abusing you. It will stop them from doing that. And so, it's that's what it is. It's an injunction. Now it's different to a general injunction because this is under the Family Law Act. So it's only those who have an associated relationship with somebody as defined by the Family Law Act that can do this. And it would be either an ex-partner, a civil partner. It could be family members or sisters, brothers, because you have an associated relationship with them, uncles, those sort of people who you've been in a relationship with, you'd be able to get a non-molestation order against them. And this is to stop them from coming anywhere near you or carrying out the acts that they carry out. And they vary. It could be a non-molestation order that is granted to a husband and wife or cohabitees who live in the same house, but it's stopping one party from either going into the other party's room or for doing X, Y, and Z. So it varies and it depends on the severity of the abuse. Of course, if the risk is very high, then the courts are more likely to exclude one party or the perpetrator in order to protect the victim and any children concerned. So, that's what a non-molestation order is, and those are who can apply for a non-molestation order. It's very important to start off with seeking advice. It's an application that you can do yourself, but often at times people who are in that situation are not in the right frame of mind to make such applications. So it's important to note that you can qualify for legal aid. It's one of those areas that you will be able to get legal aid for. So seek the advice. Contact the National Center for Domestic Violence. They're very helpful with assisting you with preparing cases and giving you advice and direction as to what you need to do. Other than that, you can make an application to court online. You can make an emergency application. This is where your life is in imminent danger, and if it's not stopped immediately, then you would you stand to be in severe danger. So you can make an emergency application, and what that is you make the application to court, and the injunction is given to you immediately. And this has to be served on the perpetrator to prevent him from coming anywhere around you. Sometimes there might be a power of arrest attached to it. So if he breaches the order, he will be arrested by the police, or she will be arrested by the police, because, not only men are perpetrators. I need to stress that a lot of women are perpetrators. And I've come across quite a lot of that as well. So it's very important to understand that, not only men, but women also abuse their husbands or their male partners. And they can make applications, make an application to court for a non-molestation order. And so you make the emergency application. If it's granted, then you serve it on the partner, and they can't come anywhere near the house, but they'll have a right to come back to court to explain themselves, to have a defense, to defend themselves. The judge will listen to both sides and make a final decision as to what needs to happen. Non-molestation orders can last for 3 months to a year, even longer, depending on the circumstances. You can always have it extended as well. So, that's what you need to do if you find yourself in that situation. First of all, always be safe, keep yourself safe. Don't stay if you think your life is in danger. But more importantly, seek advice. There's so many organizations. All you need to do is a search on your phone or online, and organizations who can assist you and guide you as to what you need to do. And of course, you can call a solicitor and get assistance. And like I said, you may be entitled to legal aid. Not always. You look at your income, of course, to see whether you can afford to pay a solicitor or not. But if you can't afford to pay a solicitor, you may be entitled to legal aid. So it's worth exploring that avenue first before going to any other solicitor who will be fee paying. So that's in a nutshell what a non-molestation order is. And it protects a lot of people, of course. But like I said, the most important thing is, a non-molestation order is just a piece of paper. And to some perpetrators, that doesn't mean anything to them. So, take yourself out of harm's way as best as you can. Protect yourself, protect your children, and deal with any applications once you are safe. So important.
Thank you very much for that. I'm going to take you back because there's a question from Auntie Louisa who asks, what happens when a parent is self-employed and tries to hide their income? What advice would you give to the other parents seeking support? And I think Angel asked the same question. There's a big loophole for those self-employed.
Yes, there is. With self-employed, they'll look at the child support agency has very, very far-reaching hands. They can look into your accounts. They could, so if you're hiding it, if it's cash, then there's simply nothing anybody can do if the money's not going into a bank account that is attributable to that person. So there's nothing you can do if it's a cash-based job and they're not putting it through that account. Not much you can do. If they are, and they're just not declaring it, the child support agency would be able to reach that far to look into it. But of course, they'll have to know that that's there. So if you know, then it's information you need to pass on to them. If you don't know, then unfortunately, there's not much you can do. It's just a question of, waiting and hoping that at some point they'll realize that you make more money when you do things lawfully than the other way around, and then you go after them then. But in the absence of that, there's not really much you can do. If it's a company and they are putting the money through the company, and they say, the child support agency will look at their accounts, will look at all the circumstances surrounding that, and will make a decision based on what they find. So it's not enough to say, well, it's a company, I'm only earning £1,000 from the company, but it's making £2.5 million a year. Well, something is wrong there, and you're a director. So, but a lot of the times, and I agree, it's difficult because people know what they need to do. And so, it's a company, it's your company, but they're down there as an employee, having no shares because they've got the family members having the shares and so forth. And that's difficult. And there's not much you can do about that, unfortunately. But hopefully, a lot of people out there are sensible and realize the need to look after their children, because, at the end of the day, they're yours. You brought them to the world, and no matter what's going on between you and mum or dad, it's your responsibility to care for them. So yes, unfortunately, not much you can do if it's cash-based and it's not above board. But if it is, and it's given the face of something else, they will look into it and will still get some money for you.
Thank you very much for that. Auntie Jackie, listening to you talk, you're not just knowledgeable. I can tell that you're very passionate about, law and what you do, about what you do. And I'm curious, I don't know if I've ever asked you this, but I'm going to ask you on air. Why law? Is this what you dreamt? Is this what you wanted to be when you were growing up? Did you want to be a solicitor?
No. I wanted to be a dancer.
Oh, I
always wanted to be a dancer. Mm-hmm. And I gathered the courage one day to tell my dad that I wanted to be a dancer. This is bearing in mind that he wanted me to be a doctor. And he says, if you're not going to be a doctor, you could be a pharmacist and so forth. So I knew where his mind was leading towards. But, I like dancing, and I fancied myself as a black ballerina, something like that. And so I did say to him one day, how back home they always ask, what do you want to be when you grow up? And you'd always say what you think they want you to hear. And I said, no, I want to be a dancer. And he looked at me and he says, dancing? Of the children whose fathers can't afford to send them to school. And I thought, okay. And that was the last. He said, no, you're not going to be a dancer. You will be either a lawyer, a doctor, or a pharmacist. And because they viewed me as one who always argued at home. I don't think I did. I always just wanted to express myself and my opinions. But that was deemed to be, you talk too much. Mm-hmm. People who talk too much back home can be lawyers. Yeah. And so I think I was sort of directed towards that, because I was not going to be a doctor. It was not for me, and I knew that from the start. And pharmacy was not for me. So it was just, I'm glad I did. I think I would have made a good dancer, though. I genuinely think I would have made a good dancer. Whether I would have been comfortable financially, I don't know. Mm-hmm. But it's I know lots of dancers. I have a very good friend who's a professional dancer. She is from Ghana, and she's doing absolutely well and enjoying what she does. So it is possible out there. And I remember I was watching the program last week with Deborah Debs, and the encouragement she got from her mum, and I thought, wow, that's amazing for a Cameroonian parent. But since becoming a solicitor, of course, I've always enjoyed what I do. It's just the joy you get from empowering people with knowledge and giving them advice. It's something that you can't really express. And when people walk out and they're satisfied with the advice you've given them or the job you've done, that in itself just makes everything okay. And particularly, I am very passionate about women's rights. And I know I say this, I don't want it to look like I am a male batterer or anything like that, because I think I try to approach it in a very fair way. But I think a lot of the times, we need to understand, the things that we need to do in order to get ahead in life. And like I've said, it's not just for men, not just for women, it's for men as well. And especially in the last 5 years, because I started doing a lot more family law in the last five years or so, I see a lot of men who are in very vulnerable positions, not necessarily because they want to be, but because of the love they have for a woman who has turned against them. And that happens a lot of times. And so it's just empowering them and letting them know what they need to do in order to secure themselves and also children. Being a mother, you just want what's best for any child, whatever the environment. So not obviously an unstable environment, but the best either way, whether together or apart. And it's I try as much as possible to resolve or to mediate, as opposed to encourage going to court, because I think there's a lot to be said for mediating and trying to resolve things, because going to court can be so draining. It's such a lengthy process, very costly, and it drains you of energy that could be used somewhere else with your children or with family members doing whatever you want to do. So yes, I'm passionate about what I do. I enjoy what I do. I probably will be doing this for a very long time to come. It is stressful, very stressful, because I deal with people's problems, and that's what I do. Very few people call me because it's a happy situation. I'm not fortunate enough to work in a city firm where it's all commercial deals and so forth. I deal with real problems and real people, and so it can be stressful sometimes. But it's so worth the rewards that you get from the advice they get and being able to help people who need the help. So yes, that's my story.
I'm glad you became a lawyer after all.
So am I. So am I.
And I'm sure Daddy is proud.
I really hope so. I mean, he did tell me he was, but unfortunately, as you know, he wasn't around to see down the line. Yeah. But, we all try to do him proud. We all try to do him proud. Yeah.
So what advice would you have for any young person who is currently in the UK, especially an immigrant studying law and hoping to be a solicitor? What's the route? How do they get, what steps do they have to take to own a firm someday, maybe?
An immigrant, very important if you're an immigrant and you are resident in the UK, because of course, if you're not resident, it's a bit more tricky. But if you're lawfully resident in the UK, it's really just the passion that you have. Running a law firm is very, very tedious, and we're regulated by the Law Society, as you know, and the Law Society have very strict rules, very, very onerous rules that we have to abide by. So, and when I say, if you're seeking advice from anybody, especially with immigration, and this is not to diminish the intelligence or the advice that non-solicitors can give you, but if you go to a solicitor, the chances are that you will get the proper advice because of the way we're regulated. And all it takes is, a phone call to the Law Society or the SRA to complain about it, and an investigation takes place. So it's so important to understand that, if you go to a solicitor, we're bound by very, very severe and strict rules that we have to comply with in respect to money, to receive money from clients, the advice that we give, everything has to be documented. We need to advise the clients in advance of what our fees are going to be, what our terms and conditions are. So, at least you understand from the onset what you're getting yourself into, what it's going to cost you, and likely duration of the process. So it's in order to do that, you have to be prepared to follow these strict rules. You have to have a law degree or any degree. So you don't have to have a law degree to become a lawyer, to become a solicitor. You could qualify as a doctor and then do a conversion course for 1 year, and then do the law, either the LPC or the bar vocational course. You can do either one of those. I know the laws are changing this year, so you no longer have to go for a training contract if you want to become a solicitor. You can use past experience, or you could, work for a firm, and that experience will count towards your qualification. So I'm not really well versed in the new rules concerning qualification, but I know they're changing drastically, because in the past you'd have to train for 2 years on very minimum wage, and it was really a struggle for a lot of people. That has changed a lot. So, look into that. Setting up your own firm, again, you have to be prepared to follow all the rules and regulations. It's hard work, trying to get clients coming in and doing the work as well. But it's, it's very rewarding, if you do that. And of course, if you have a business partner like I do, who is very hardworking, and, it makes the journey a lot easier. So, it's worth pursuing if that's what you want to do. It's not impossible, and it's not something that is so far. I mean, it's so easy to do if you want to. And nowadays, there's so many of us, not only Cameroonians, Africans, who have law firms. Reach out to either one of them and just ask for advice. I can't imagine anybody coming to me and asking me, that they want to set up a firm. I'll be more than happy to guide them, in what the requirements are and what they need to do to do so. So yes, but get the qualification, law degree or any degree, and then the legal practice course, and then you're ready to go.
You heard that from solicitor with 19 years experience, right, Jackie? Okay, I'm so proud of you.
Thank you.
You've done well. You have so many people in the comments, who are proud of you as well. And
thank you very much. I really hope that this was, the whole idea was to inform, and so people know what if at the very least just gets you thinking, and lets you know that there is a way out, even if you haven't been able to grasp what all that I've said today. If it's resonated with you, just pick up the phone and call the Citizens Advice Bureau or your solicitor, or any solicitor, and just ask questions. Or you
can call Solomon Shepherds.
You can call, of course you can. I'm just presuming that your audience are wide and far, and not necessarily all in London. But of course, if you're in London, please give us a call. We're more than happy to help and to guide you. But important is to just seek their advice and be certain that you're satisfied with that advice, and then you act upon it. So that's the most important thing.
Thank you. Thank you very much. And you'll be surprised to know people are joining us now. So what I'm going to ask you to do, I know your brain is almost tired. We said an hour, but we're just above an hour. So we're working within time, which is African time, now.
Yes,
so if we can just do a summary. So on especially with the deadline. So we've talked on immigration rights with regards to Brexit, and we've talked on cohabitation rights with regards to property, and then we talked a bit on child support, which you really give a detailed explanation on, and then lastly we've talked about if you find yourself in a domestic violence situation, non-molestation rights. So I'll start with the Brexit. What are the key things for people to remember before they even start doing their research?
Key things are the dates. 31st of December 2020. Make sure you're present in the UK, otherwise you won't be able to qualify for either settled status or pre-settled status. So you need to be present in the UK, exercising your treaty rights, i.e. working, student, on pension, whatever the case might be. Of course, you can't be on pension if you haven't worked. So, you need to consider that. 31st of December is the deadline for that. Now, if you're already present in the United Kingdom, you have until the 31st of July 2021 to make either a settled application or pre-settled application. And of course, that will depend on your circumstances. Again, seek advice, but those are the deadlines. After that, you won't be able to make any application under the European, under the EEA rules. You will now be subject to immigration, UK immigration rules, which are a lot more stringent and works on a point-based system. So it's a lot more difficult, and especially for a lot of our European audience who have family members here who are not necessarily lawful. As a European national, it's easy to convert that to a lawful status. With the immigration rules, that's practically almost impossible to do. So if you are in the situation now, with an EU applicant with dependents who are non-European nationals who are not lawful in the UK, please deal with that before the 31st of July. If you're thinking of relocating or exercising your treaty rights, do that before the 31st of December 2020. So those are key dates for Brexit and EU laws. With respect to Home Office fees and waivers, just consider it. If you're struggling with the fees, if you think you're destitute or at risk of being destitute, make an application for a fee waiver. They'll ask for a lot of information. Give it. You just don't know. You've got nothing to lose. To make the application. It will not cost you a lot of money if you go to a solicitor, because it's a standard application that can be made by solicitors. So you pay a lot less than any fees that you pay down the line. However, it's an application that you can make yourself as well if you felt confident enough to do that. Of course, whatever information you give will be used to support any application you make down the line. So you've got to be very careful. And my advice is, always use a solicitor. It's just not worth trying to do it yourself if you're not certain or it's not something you've done before. So, that is with fee waivers. You get your Home Office fees and the IHS fees waived completely, which will leave you with just having to pay your legal representative fees, or if it's something you do yourself, that you can do yourself. And this applies to people who are renewing their visas, spousal visas, applications made under the Human Rights Act based on children or private life. Those sort of applications would really be the sort of applications you need to get the fee waivers for, because not all applications would enable you to be eligible for that. Okay. So that's Home Office fees and fee waivers. Now, to do with cohabitation, important if you're in a relationship or cohabiting with somebody else, try to set out from the onset, by having a cohabitation agreement. Try and get a will in the event of one partner passing away. So it's set in stone what your intentions are and what you want. In the absence of that, if you've got property, depends on how you hold it, but what the courts will look at are the intentions of the parties and what was said to the other party who is not a legal owner. So, for example, not a legal owner, what was said to them and what they believed, and did they act upon that belief to their detriment? And so things like that will be looked into. Did you contribute towards the purchase of the property? Did you, pay for the kitchen, or did you pay for an extension? That sort of thing. It's not enough to say, I just paid for the electricity bill. If you've made a substantial contribution towards the upkeep of the property, then you should be entitled to you should have a beneficial interest in the property.
Quick question. What if you're not working and all you're just doing is being the stay wife one?
Right, yes. Very, very, very important question. Well, then they look at the intentions of the party. Was the property bought in order for you to raise a family? Okay. What was said to her who's not working? Did the husband or the wife say, don't work because you're better placed to stay home with the children, I'll do the work? Was that a conversation that was had? If it was, then, it goes without saying that, you intended her to have a beneficial interest in the property, because looking after children is, considered a job in itself, irrespective of what people might think. So, these are the things that, don't feel because you didn't work and you stayed home and, you know, you got money from your husband, that you're not entitled to anything. It doesn't work that way. You kept the house clean. You may have done some DIY here and there, you know, and you looked after the children who are his children as well, or her children as well. So yes, you can still make an application under the Tolata if that was the case. And again, very important, irrespective of how you hold the property, joint owners, so you're both legal owners, but one party has contributed a lot more than the other party, and the party who's contributed less wants to have an equal share. You could, I mean, of course, if you want to give them the equal share, that's fine. But if you feel wronged by that, then of course you can make an application for the courts to establish what interest each party has by the intentions, or how it has been displaced down the line by what actions they've committed or done. So, you know, important to bear that in mind. Very important as well, lastly on this, if you're buying a property and you're not going to be the legal owner, but you've worked hard and you have your 20,000, 30,000 to add towards the deposit, get a declaration of trust. It not only protects you down the line, it's a very simple deed that can be prepared by a solicitor and registered against the property. You know, but not only does it protect you down the line, but it also protects against anybody who's trying to buy the property or who is trying to sell the property would know that somebody else has an interest in that property. And so we need to investigate that further. So, you know, it protects you to a certain extent. It's not a matrimonial homes right notice on the property, because that's obviously a lot stronger than a declaration of trust. But it shows any third party, either a mortgage a company or a bank lending a loan, that somebody else has an interest in the property, and then you take that into account in lending. So if a partner is buying and you're not going to be a legal owner on the property, but you're contributing towards the purchase of the property, consider a declaration of trust or a deed of trust in your favor. So at least that protects you down the line.
Okay. And lastly, you can get non-molestation rights on
non-molestation or
they say you've over-delivered. I should let you go.
Thank you. No,
after a long day at work as well. I know. But
no, it's been such a pleasure. But to go back on the non-molestation order, you know, if you feel you're at risk and, you know, physical abuse, psychological abuse, coercive control, you know, please seek advice. National Center for Domestic Violence, you know, you can contact them, or any other organization that deals with domestic violence. They'll be more than happy to help you, and will also assist you with applications. But of course, if you can't get through to them, contact a solicitor. It's an application that can be made online or in person, and it will protect you from any abuse from a third party who you're associated with. So you can't make the application for a non-molestation order against a colleague at work. It has to be an association within the Family Law Act. And that will protect you for a period of time. And that could also have a power of arrest in case they breach the order. So, you know, things to think about. But please, I say this, and I know people think, you know, why am I going to pay the solicitor money because I can do things online? Online just gives you part of the information, and they are not looking at your specific circumstance. So please go and see a solicitor and just get advice. And with non-molestation orders, like I said, you will be entitled to legal aid. So consider that if you are struggling financially. But otherwise, you know, call your solicitors. You can call us. I'll be more than happy to take your calls. You know, we've got two other solicitors, Isaac and Delia, who deal with various matters here in the office. And, you know, we'll be more than happy to help. We've also got lovely assistants who are well-versed and understand the needs of clients, who will be more than happy to help. So please give us a call your solicitor, but just get advice and be informed.
And on that note, this has been brilliant. Thank you. Really informative, very useful information. I've learned a lot as well, and I can, you know, pass on some of what I have learned from you to people who might not find themselves in such situations. And for you who's watching, if you know anybody who could benefit from this, the number for Solomon Shepherds is on the banner that's running across where you see the woman experience. Their number is there. It's 028, Auntie Jackie,
028 801 0214.
Oh, yeah. Thank you. And your aunt,
SolomonShepherd.com, you know. solomonshepherd.com as well. You can send a message, to us through solomonshepherd.com. Yes.
Yeah. By the way, your auntie is very proud of you.
Oh, thank you, Auntie.
But thank you guys so much for watching. And if you've got any other questions, just leave them in the comments, and I'm sure when you've rested a bit, maybe sometime over the weekend, you come back and
I will certainly. Please leave questions by all means. I'm more than happy to respond. Of course, I can't advise on any particular case conclusively, because it's just not possible to do that unless I've spoken to you. But general questions that you have, I'm more than happy to respond to that. Otherwise, please give me a call. I'm more than happy to speak to you briefly over the phone or in consultation if that's necessary. And of course, you don't have to come to my office. We can do it online because of COVID. Everybody does things online these days. So, I've got, we do it either through Zoom or Teams. So we can have the consultation over online as well. So you don't have to physically come to my office.
Yeah. And the rest, everything else, just thank you. So many people came out to watch today, Auntie Jackie.
Brilliant. I'm glad that they have done. Thank you all for the support. Everybody has been rooting for me, so I'm quite chuffed by that. And I'm really hoping, I think for me, the hope is that, somebody's been able to take something of importance from this show, because that's the whole point, the whole point of, like you said, of the platform. But more importantly, today was just to empower people to understand what their rights are. So if you have, I'm really, really glad you have. And if you think you need more, send a message on Facebook or contact me. And either way, hopefully we'll be able to help. But thank you so much, Anu. I'm your best supporter. My actress sister, I tell everybody, my normal actress sister. Yeah, so even happier to be on your show and enjoying the show a lot.
Thank you. It's always I always feel so happy when I have members of my family on this show, because that my show has not gone to waste, right? Because I'm the star of the family.
Yes. Anyone who cares to listen knows that this is my star sister.
Yes. So, but Jack, thank you so much.
Thank you so much, Anu. And we'll catch up. Thank you very much, all of you who have watched and supported and made this platform brilliant. Thank you very much, and all the best.
Thank you. I'll take you backstage now, so I say good night. All right. Okay. Thank you guys so much. And the whole family is out here in full force. I see you, Cynthia. I see you, Sister Flo. I see you, Anita, Mami. Thank you guys, Rosemary, Black. Everyone's watching tonight. Thank you guys. And the other side of Wole's family. Thank you guys so much for the support for tonight. And please, we do this every Friday at 8 p.m. GMT or UK time. So join us again next Friday. And if you're new to us, like I said before, we have over 50 episodes that you can watch. So just take some time and browse through our past shows and see what takes your fancy, and then watch it so you become part of our tribe. And like Auntie Jackie has said, Brexit goes into effect on the 1st of January. No, sorry. So the transition period comes to an end on the 31st of December. So from the 1st of January 2021, we are officially out of the EU. So if, like she said, the dates to remember, 31st of December 2020. If you plan to relocate to the UK, you should be here before then. And then there's so many other things that you need to prove. All you need to do is just give Jackie a call, and she's happy to answer them and go through them with you if you need her advice. But thank you guys. Do join us please next week. And if you haven't done so already, please like our page. It's the GORETTI Experience page on Facebook, and it's the GORETTI Experience page on YouTube as well. Subscribe on the YouTube pages, and spend a few moments to watch whatever you can, whatever tickles your fancy, like I said earlier. But thank you for watching, and I'll see you on Friday at 8 p.m. British time, GMT. Thank you. Bye-bye.
Everybody wants to find the perfect match for their financial needs. Secured savings, stress-free access to affordable loans, instant mobile money transfers to MTN and Orange Cameroon, and even a share in the profits as a member owner. For over 7 years, RENCAM Credit Union has been the perfect match for Cameroonians living in the UK and other nationals with interest in the Cameroonian heritage. Visit rencam.co.uk. Join RENCAM Credit Union today, achieving success together.